the second DMH Stallard webinar. In this webinar, we are going to be looking at some difficult questions associated with collective redundancy consultation. I'm joined today by two of my colleagues in the employment team, Greg Burgess and Will Walsh, who will be known to many of you and I'm sure are helping you through some of the difficult issues that we are currently facing. Some housekeeping before we dive into the webinar. As with last week's webinar, we will try and answer as many of your questions as possible. We've had quite a few sent in advance, so thank you for that. But if you've got any that you want to ask throughout the course of the webinar, then please use the Q&A button and we'll be able to see them as we go through the webinar. There's only one poll today in the webinar, but for those of you watching on smartphones, you may need to scroll down to the bottom to submit your answer. And in terms of a running order, I'll kick off by looking at when it's necessary to collectively consult and what it involves. I'll then hand over to Greg, who will look at some of the trickier areas relating to when the proposal arises, the length of consultation and establishment issues. And then we'll have a break for some question and answers. And then Will look at some of the practical issues concerning consultation with your furloughed and remote workers before we come back to a final question and answer session. So kicking off, when is it necessary to collectively consult? So where an employer proposes to dismiss as redundant 20 or more employees within a 90-day period at a single establishment, there is a duty to collectively consult with appropriate representatives of affected employees and also notify the government. And that consultation needs to last for 30 or 45 days, depending on the numbers involved. So between 20 and 99, a 30-day consultation, 100 or more, it's a 45-day consultation. And that consultation is before the date of the first dismissal takes effect. The relevant legislation is in section 188 of the Trade Union, Labour Relations and Consolidation Act 1992, which is a bit of a mouthful, so we often just paraphrase that to section 188, which we will do throughout the course of this webinar. The collective redundancy provisions in section 188 can have important commercial consequences for organisations. Firstly, there's effectively a moratorium on your dismissals, so you can't dismiss anyone until the dismissals can't take effect before the end of that period of consultation once it's started. And secondly, the maximum sanction for breaching those obligations is a payment of up to 90 days gross pay per affected employee. So that can add up to quite a substantial amount. A key thing to remember with the duty to collectively consult is it has a wider meaning than traditional redundancy situations such as disappearing jobs or workplace closures. The definition of redundancy for collective consultation purposes is effectively any non-personal dismissal. So if you've got a proposal to change contractual terms, such as job functions, hours of pay, rates of pay, and effectively if those employees don't agree to the change, they would be dismissed and offered re-engagement on the new terms, then that would fall within the definition of redundancy under the legislation. And so depending on the numbers, there would be an obligation to collectively consult. There's frequently employers find themselves in needing to make redundancies in successive batches. So in determining whether section 188 is triggered, that can cause a bit of a headache. If you're already started collectively consulting with a number of employees, then no account is taken of that separate collective consultation. So if you've got, if you're consulting with 30 staff about proposed redundancies, and then you have a separate proposal for a further 10 redundancies the following month, you wouldn't collectively consult with those 10, provided they weren't in your mind at the start of the first consultation period. But a trickier situation arises where collective consultation hasn't started. So you might have initially proposed 10 redundancies and then decide you needed to make a further job reduction and propose another 15 redundancies. The original proposal wouldn't itself trigger collective consultation, but if the second batch if the dismissals are due to take effect within the same 90-day period, then that second batch could well trigger the obligation to collectively consult. So the question then is, what do you do with your first 10 if you've already started with those? And that often depends on where you are in the process. So there's a case from 1978, and we have to go back that far for much case law on it, unfortunately, involving nationwide haulage, which said that the law doesn't retrospectively impose an obligation to consult in respect of dismissals that have already happened. That would be to demand the impossible. And only if it would only amount to a single proposal for the purposes of collective consultation if you already had that second batch in mind at the time the first batch was proposed. But it's important to note from that case that concerned a situation where the first batch of dismissals had already been put into effect, so notice had already been given. So it wasn't really a proposal anymore for those that first batch. It was really a fait accompli. They knew they were going. Where a first batch is still only a proposal, when a second batch is then proposed, there's a strong argument that they must all be consulted over if they're all going to take effect within the 90-day period. So what do you do in that situation? Well, you could potentially delay the second batch, so they take effect outside the 90-day period, and that would be measured from the date of the termination of the last termination from the first batch, so you would count 90 days forward. Clearly, the cost of that is going to have to be balanced against the risk of the protected award, or you could decide to collectively consult. But as you can see, it is a tricky area. Tribunals are alive to employers who are looking to deliberately try and split up proposals to reduce numbers. So what we always say to clients is, if you're proposing a first batch, are you absolutely sure? Have you worked through whether you think there may be further batches within the same 90-day period? If there are likely to be, you may want to sort of bite the bullet and do your collective consultation now, rather than run the risk of trying to unpick something later down the line. If there does turn out to be further redundancies proposed when they genuinely weren't expected, then you need to think carefully about whether those collective consultation obligations have been triggered, and take advice if you're uncertain on anything. I thought it'd be useful now to get a little sense of how many of us were proposing multiple redundancies over the next 3 months. So I've got a little poll there to complete. We are certainly talking to clients a lot more about redundancy planning as a part of a suite of measures to respond to the current economic climate. So we'll just wait for the results to come in. Live technology is always a little slow in the morning to get going. Right, so a real split there, but I think it's quite clear there that that over 2/3 or 3/4 of you out there are really thinking either yes we are, or we're unsure and might be thinking about it. So yes, it really is a live issue, and that probably aligns with what we're seeing with our clients as well at the moment. So in terms of collective consultation itself and what it involves when you get to that stage, I've put some headlines there on the slide. You need to identify, as a first step, your affected employees. And remember, this can go beyond those, beyond the obvious, as those that are immediately at risk. And it could include those who are affected by measures associated with the dismissals. So for example, if there's going to be significant changes to reporting lines or other organisational arrangements. You then need to identify your appropriate representatives, and they could fall potentially into 3 different categories. So you could have trade union reps, directly elected representatives, which I know Will be talking about later, in terms of the practicalities of arranging those, or you could already have a standing body of elected representatives in place. Once those reps are in place, there's certain minimum information that needs to be provided to them in writing, and that includes things like the reason for the dismissal, the numbers involved, proposed selection criteria, etc. So there's a minimum information there. And then your consultation needs to look at ways of avoiding the dismissals, mitigating the consequences, and has to be entered into with an open mind, which I know that's something that Greg will be touching on as well in terms of when a proposal has arisen. And then finally, there's an obligation to submit your HR1 form to the Secretary of State and provide copies to each employee representative. And failure to do so is actually a criminal offence, so it's important that this step isn't missed out in all of the planning process. So I'm now going to hand over to Greg to look at some of the difficult questions relating to proposals, and do remember to keep those questions coming in.
Thanks, Abby. Good morning, everybody. Just before I get into the detail of what I'm going to be looking at, I'll just sort of share where I think we are in terms of what we're seeing from clients. And we're often asked, what are other businesses doing? I think where we are, given that we're now several weeks in to lockdown and pandemic, is that we've got through the phase and the urgency in relation to furlough. But very much it is the case that many businesses are now looking at this situation with a view to reshaping their businesses, whether that is just as a response to the current situation, or whether some of the more entrepreneurial clients are saying, well, we needed to reshape our business anyway, this is the chance to do so. So we are seeing a lot of clients who are now going through the restructuring proposals. And what my first question addresses is, when actually is there a proposal to dismiss that triggers the duty to collectively consult? Now, most HR professionals are working with their senior management teams, looking at what the requirements will be post-lockdown, and starting to build a picture as to how many roles and how many people may be affected by any proposals and any downsizing. But the question is the obligation to collectively consult triggered yet, or is it at a later stage? And we start by looking at the European legislation and the UK legislation. We have a slight conflict in terms of the wording of the legislation. In Europe, it talks about the obligation starting when redundancies are contemplated. In the UK legislation, the Section 188 obligations around proposals to dismiss. What's actually clear, though, from the case law here is that the employer cannot begin consultation with a closed mind. Abby just touched upon it. You've got to go into this with an open mind. So if you're in a situation where you start your collective consultation and you're saying to your elected reps, we've decided we're making these changes, these numbers, this is who's going to be affected, and let's just begin the process of selecting people, let's say. Well, in that situation, you're going into it with a closed mind. The obligation to collectively consult is triggered arguably much earlier than that. And just to look at a couple of examples from the case law, there was one case where there was an assurance company, it's called Refuge Assurance. They knew they had a dramatic downturn in business, they had a number of branches throughout the country. And what they knew is that they were going to have to make a number of redundancies across the branches throughout the UK. What they didn't know, and they hadn't decided, was exactly how many were going to be made at the various branches and exactly which branches were going to be affected. But what the tribunal said was that because they knew there was going to be more than 20, they didn't know the actual detail, but at the point they knew that there was more than 20, the obligation to collectively consult was triggered. So it's possibly the case that much earlier than people realise that obligation to collectively consult is triggered. And you need to think very carefully about that. There was another case which shows a similar line of thinking by the tribunal, where a business was in a critical condition. There was two options. One was an insolvency route. The second was a sale of the business. But there was two open options, and the board of the company were looking at both options. In that situation, even though there was two open options, the tribunal said that the obligation to collectively consult was already triggered when they knew that there was a chance that it could go down the insolvency route, which would lead to a collective consultation obligation. It wasn't the case that the business had to close out the sale of the business as an option before the obligation to collectively consult was triggered. So think very carefully as you start your plans as to when you want to start collectively consulting, because it will take time to build the plan and then to elect the reps and go through the process that we've been talking about. The second question on the slide deals with an issue around a potential defence to the obligation to collectively consult. What Section 188 says is that you must collectively consult if you're proposing to dismiss 20 or more at one establishment within a 90-day period. But if there are, quote, special circumstances, unquote, that could arise, then the obligation to collectively consult is removed. And we've had a number of questions from clients around whether or not these current circumstances are special circumstances. And what the test that the courts have developed over the years is one that they asked whether it was reasonably practicable in the circumstances to collectively consult. And very rarely, in truth, do we see that defence succeeding. And it is our view that in the current circumstances, that defence wouldn't succeed, because the furlough scheme that's been put in place through to the end of June currently gives employers every opportunity to plan, to consult, and to go through a robust process to effect multiple redundancies. And in those circumstances, we don't think that there's going to be defence that you can rely on. So if you are looking at multiple redundancies of 20 or more, then the obligation under Section 188 is triggered, and we don't think there's going to be a defence in play. Okay, we can move to the next slide, please. Now, one area where there is always a discussion is around the definition of establishment. Now, if you are a business and you have one site and you are going to make more than 20 people at your one site, then it's relatively straightforward. Your establishment is your one site. But many of you will be parts of companies which have sites all over the area, all over the country, but certainly you may have more than one site. And the question then is, how do we define the establishment for the purposes of the Section 188 obligation? Let me take you through what the courts have developed in terms of the way of thinking under the case law, and then I'll try and bring it into some sort of practical sense. Ultimately, the position is that the tribunal will be looking to protect individuals and will be looking to define the establishment relatively broadly. But let me just take you through some examples first of all. So cast your minds back to 2008, when the good old days of having Woolworths on the high street. Well, unfortunately, those days came to an end in around 2008 when Woolworths went into administration and suddenly all the shops were closed. And there's some well-known case law which developed from the closure of Woolworths. And what happened was that case went through the UK courts, it went up to the European courts, and then came back to the UK courts. The question was each branch of Woolworths a separate establishment, or could they be grouped together? So if I worked in a Woolworths in Worthing, let's just say, and there was only 15 people there, and all 15 went, could those 15 people say, well, you should have collectively consulted me because I was part of a bigger grouping? And what the ultimate outcome of that was that the court decided that each individual branch of Woolworths was a separate establishment. So it did mean that those employees who were in the smaller branches with less than 20 people weren't able to bring a claim for a protective award. That case law has been developed over the last few years, and the next key case was one called Athenike. And in the Athenike case, what the court said is that the broad approach needs to be looked at in terms of what is the local employment unit. So off the back of Athenike, we've had cases which say, for example, that a school could be a local employment unit, a factory could be a local employment unit. Let's just think about how this could work in practice. Because in practice, what can happen, excuse me a second. In practice, what can happen is the local employment unit could be more than one site. So let's say we've got a manufacturing business which has a site in Brighton and one in Eastbourne, let's just say. But they manufacture different things, they have different customers, they have their own sets of staff. In that situation, they may well be separate establishments. But if they are working together and they have employees that move between sites, have similar suppliers, similar customers between the two sites, and the management is the same, then it may well be that that is held to be one establishment. So you've got to very much look at the facts. One other issue in this, and this came up last week with a client scenario I was looking at, is if you have one site, and let's say your site is, in this situation, it was a site in London, and in that site it was a global media company. In that site they had a number of different subsidiary companies. If you have subsidiary companies at one site, you do not have to look at the whole site for the purpose of the establishment. So in my scenario, it was a global media company. The employees were working for an events part of that media company, and there was about 30 employees in the UK in the events part of that business. What the case law is quite clear on is that you have to just look at the subsidiary for defining the establishment. So in that situation, there was around 10 redundancies in the event part of the business, and you didn't have to look at the other redundancies taking place within the London site. Second question on that slide, if we've got a group of employees who work from home permanently, what is their establishment? Okay, so again, we looked at the case law to try and help us on this. And what the case law has developed is an analysis of what actually happens in terms of those remote workers. So in one case, there was a field sales team, but the local sales people were actually part of the local branch, and they were reporting into the branch manager of the local branch. And in that case, they were found to be part of the establishment, being the local branch. Whereas in another case, again with field salespeople, they were part of a UK-wide sales force, reporting into a sales director, didn't have any connection with the local branch. And in that case, their establishment was their grouping of salespeople. So if people are working at home permanently, you've got to look at where their connection is in terms of their local employment unit. Okay, we can move to the next slide, please. Okay, and just finally from me, looking at a couple of questions which we see come up over and over again when we're dealing with collective consultation. Because the scenario is this, is that you start on day one of your collective consultation by notifying the Secretary of State about your redundancies through your HR1 form, which is what Abby has mentioned. You elect your reps, you begin consultation, and quite often it happens, not always, but quite often it happens that your consultation, after 2, 3, 4 meetings, say, we're into week 3, let's just say, of the 30 days or the 45 days, and you feel that actually you've discussed everything with the reps understand everything, the reps have had a chance to respond to the proposal, and you've responded to their response. And you take the view, well, we've covered everything, there's nothing more to consult about. And what is clear from the case law is that you are able, at the point that you have consulted over everything, to effectively close the collective consultation before the 30 or the 45 days as appropriate. So we do see, after say week 3, often the closure of the collective consultation in those circumstances. And what then will happen more often than not is you move then into individual consultation, and you go through the individual consultation as you would do normally. And then just a final question, which again links to what I've just said about the closure of the collective consultation is, can we issue notice to staff before the end of the collective consultation period? So you've gone through your collective, and let's just say it's taking you 20 days to do that. You've gone through individual, that's taking you another week, so 27 days. And let's just say we're in a 45-day period of consultation. Well, in those circumstances, you might want to get on and issue notice. And often for sound financial reasons, not get on and issue notice because you want to reduce the financial cost. And what the case of Junk, J-U-N-K, said, was a European case, is that it is possible to issue notice before the end of the 30 or 45-day period. The key is, as Abby's touched upon earlier, is that the dismissals mustn't take effect before the end of the collective period. The notice can be issued, but dismissals cannot take effect before the end of the collective period. Okay, so that's all I was going to cover for now. I think we've got some questions, have we, Abby?
Yes, we have. Yeah, thank you for your questions. So I will start off. So we've had a question about fixed term contracts. So fixed term contracts that are due to expire and whether they count towards your numbers for collective consultation. And the answer to that is no, they wouldn't if they are just expiring naturally. The only way that they would is if you are bringing them to an end earlier than their natural expiry date. So that's that on fixed term contracts. We've had another one, Greg, I'll ask this to you. If we've got 20 or more staff and have gone through a collective consultation, how many employee reps should we have for, say, 40 people if we've got them at risk?
Okay, yeah, good question, and we have that come up a lot. The answer is there's nothing in the legislation which prescribes how many reps you should have. What I always say to clients is that you've got to focus on making sure that there's enough reps to effectively be the voice of the individuals they represent. So if you've got 40 redundancies, let's say you've got 100 employee business, you've got 40 redundancies, and let's just take an example where you've got, say, a finance team of 6 people. I would expect you to have at least one rep representing the finance team, who can then be the liaison between those 6 people and the employee rep forum. So it's not prescriptive in terms of the exact numbers, but you've got to make sure that your employees do have a voice, because the last thing you want when you get into individual consultation is you speak to an individual and they say, well, I had various questions, I wasn't happy about the selection criteria, I tried to speak to my rep and they weren't available. So just make sure you've got enough to properly represent your staff. The only problem we then come up against often is actually finding enough people who are prepared to do it. Yeah.
And then linked to that, Greg, if you've got 10 separate departments, let's say, with different business cases, but you have got a collective, you've got your numbers for collective consultation, could you keep the collective consultation within each department rather than have group meetings and each business case being explained to each rep because they really won't have any association with that other department? So I think, would you bring them together into one group meeting for the reps, or could you keep it all separately as long as you are providing information that you need to those reps?
Yeah, I think your starting point is you're going to get everyone together in terms of the elected reps from the various different departments. Your starting point is that you're explaining the proposal overall. Now, if that proposal primarily or solely affects, or certain aspects of the proposal solely affect, let's say, let's just keep it on that same example, the finance department, then you could, in theory, focus some of your discussions, separate discussions, just on the rep for the finance department. That's quite unusual. What I would expect you to do is to keep all the collective meetings together with all the reps for the first 2, 3, or 4, and that should probably get you through where you need to be in terms of closing collective consultation. And then individual impact comes through when you go through into individual consultation. So generally keep the collective reps together, but it's not impossible to isolate, let's just say, the finance department because of the impact on them.
Yeah, thank you. And then I think just before we move on to Will, we've got another question. Do employees with less than 2 years service need to be part of a collective process, or could you let them go early? Unfortunately, yes, they would fall within the numbers. So you wouldn't be able to get around or reduce your numbers for that. The length of service isn't relevant for the purposes of triggering the obligation to collectively consult, albeit further down the line, you would have reduced risk in terms of unfair dismissal, clearly, for those on an individual basis. So to avoid us running out of time for Will's really important bit on the practicalities, I'm going to hand over to him now, and we'll come back to more questions at the end. So Will, over to you.
Thank you very much, and good morning, everyone. So Greg and Abby have set out the basics and the background in terms of the legal to consult basis. What I'm going to cover off in the next section is taking a look at the practical issues that we all face, in particular when some of you will have a number of staff on furlough, and most of us will have at least some staff who are working remotely. And this brings a whole fresh set of challenges to our legal obligations. So we're going to take a look at those. So first up, so a couple of common questions that cropped up very early in this whole lockdown process. So I'm going to take the first two questions on your slide there together. So the first question is, can we start collective consultation when some or all of our employees are still on furlough? That was a big question asked at the very start of the announced furlough scheme. And then following on from that, so being combined with that, the issue of, can an employee carry out duties as an employee rep while on furlough? So looking at those two things together and breaking it all down. The first question is, the big question right at the start was, are we even allowed to make people redundant if we're taking advantage of the furlough scheme? There was quite a lot of speculation when the scheme was first announced that maybe there would be rules in place to say that the whole purpose of the scheme to save jobs, to prevent employers having to make redundancies in the first place. So therefore, was there some kind of rule couldn't make employees redundant while they're on furlough, and possibly even have to repay furlough money if you made redundancies for a certain period of time after the end of the scheme? Well, the good news for employers is that none of that followed through in the guidance. And in fact, the guidance is now explicitly clear that you can make an employee redundant even while they're on furlough. So that one is answered absolutely black and white. Yes, you can make an employee redundant. The second issue that then followed on from that was, okay, fine, we can make an individual redundant, but what about collective consultation? That's going to involve individual meetings, but it's also going to involve the collective consultation meetings with employee reps. An employee on furlough, it was made clear in the very first set of guidelines that anyone on furlough cannot do any work for their employer. So the unanswered question for a good period of time was, well, if an employee rep is doing their job as an employee rep, might that count as work? And if it does, could that then jeopardize their status as a furloughed employee and impact on your ability to claim a grant to cover their salary? Again, luckily, as of last Friday, in the latest update on the guidance, it addressed that specific point. And again, good news, it's stated very clearly that an employee rep or a trade union rep can carry out their rep duties while they're on furlough. So again, we've got absolute crystal clear answers on those two things. The one thing that hasn't been addressed expressly in the guidance, at least not yet, is the slightly wider issues. We know, yes, you can make a redundancy. Yes, you can, an employee rep can do their job on furlough. But what about the wider workforce? If they're on furlough as well, if the rep is then speaking to them, gathering feedback from the individuals, so they're not doing their rep job, but they're just being spoken to as individuals, is that okay? Could that be classified as work as well? It's not covered in the guidance, so we haven't got a black and white answer on this one, but our strong view on this one is that it must be okay to do that. It wouldn't seem to carry any kind of logic if the answer was otherwise, because by default, if the government have said, yes, you can make furloughed employees redundant, and yes, you can ask an employee rep on furlough to carry out their rep duties, bearing in mind that most reps will be one of the affected employees as well, it would seem a complete nonsense to be able to say a rep can do their duties, but they're not allowed to speak to the staff. So I think logically it must follow that that you can ask employee rep to engage with your body of employees, and that won't jeopardise furlough status. So those two are, I think, are relatively straightforward. The trickier issue is the last question we have there on the slide. The employees being consulted about their own situation is one thing, but what about a situation if you've got a manager who's on furlough? To what extent can the manager get involved in the consultation from the business side of things? In other words, could they conduct consultation meetings with the reps, putting across the business case to the reps, gathering feedback from the reps, considering business proposals put forward by the reps, making decisions on those proposals, all of those sorts of things. Our views on that one, again, it's not covered in the guidance, but our view is that that particular type of activity carries a very strong risk of being classified as work. The reason being that the government have said when they've dealt with the issue of an employee not working on furlough, what they've said about that is that what the employee shouldn't be doing is, first of all, generating revenue for the business, and secondly, carrying out services on behalf of the business. Now, if a manager's doing their job and making business decisions, they're not generating revenue, but I think it very much falls into the category of them providing services to you as a business. They're making business-related decisions. They are very much representing the company and doing the job that they're expected to do as managers as well. So an employee represents their own personal interests versus a manager making business decisions for the business as part of the role as a manager, I think very much falls into the category of doing work. So if you had that situation, you've got a manager on furlough, you needed them to get involved in the process, I think you'd have to think very strongly about removing that individual from furlough, at least on a temporary basis, while they carry out their duties. So moving on, we've got all sorts of practical issues that have been thrown up by clients in recent weeks about how they deal with the day-to-day practicalities of carrying out a consultation process. The first one in collective consultation, right at the very, very beginning of the whole thing is, well, if you haven't already got an elected body of employee reps or a recognised trade union, you need to elect employee reps, or rather allow the employees to elect reps. Normal day-to-day business, again, if we go back 2-3 months, it was relatively straightforward. Your legal obligation is to make suitable arrangements to allow an election to take place. That's the basic obligation under section 188. Only other thing, again, there's a fairly long list of bits and pieces that you have to do, but the highlights are you making the arrangements. And the second one, just to draw to your attention, is that it says that when a ballot to elect reps is arranged, where possible, you should try to make the arrangements so the ballot is done in secret. As I say, in normal times, relatively simple process. It could be even as simple as employees put themselves forward as candidates, and then your other employees, they're in the building, they could simply write down names on a piece of paper, drop them into a hat. Secret ballots, very easy to arrange in person. Most of us haven't got the luxury of doing that right now. Whole different set of challenges when you're trying to do all of this remotely. One thing that possibly has developed since around the 23rd of March, when we all went into lockdown, is I think a lot of us have become a lot more savvy in terms of what IT solutions are out there that do give us a bit more flexibility. But there are various different ways that we've come across that you might want to think about. So there is never going to be a one-size-fits-all type answer here. It very much depends on your workforce, your employees' own access to IT, what you've got available, what works for you. But in terms of a couple of bits of pieces that our clients have looked at when dealing with this particular problem in recent weeks. One, just to draw to your attention, is that generally unknown, but it is out there, that there are external bodies that will conduct a balancing process for you. That's what their business does. They will, you outsource the job to them so that they will collate names of candidates for you. The employees could get in touch with the director as an independent body, and they will also arrange the vote for you. And so that will all be done completely independently, in secret, and you can carry out the whole process remotely in that way. So that's certainly a solution to look at. Downside, of course, being that it will come at some additional cost, not significant, but nevertheless some cost nevertheless. Another possible solution, again, it very much depends on your business and what works for you and your body of employees. We've certainly had some clients who have done a similar task to what I just described, but they've done it themselves in-house. In other words, they have a nominated employee, possibly from HR, possibly externally, depends on the dynamic, and it really comes down to a question of trust in terms of confidentiality apart from anything else. And that individual then gathers the names of employees who wish to put their hands up and put themselves forward to be elected as a rep in the first place. And that person will also then deal with the election process. In other words, they will hand out the names of the candidates to the employees, and the employees will then email them or whatever communication method works best for you with their vote. That's done in strict confidence with that individual. Say again, another possible solution, very much to say, it depends on understanding and trust in strict confidentiality, but it can be done that way. But really, it's up to you to work out what works best for your business, bearing in mind your legal obligation that you need to make the suitable arrangements to allow that election to take place. So moving on, so once you've elected your body of reps, then the next headaches or problems you need to get around is the issue of how do you communicate with staff as a whole. And that's going to be a question of, in the context of making general announcements to staff, but also outside of collective consultation, you will also inevitably have individual consultation meetings as well as a separate legal obligation. So you're going to need to communicate with all of your staff in some way, shape or form on those things. And also in terms of your group meetings with your employee reps, how you're going to communicate with them. Again, when it comes down to this, it's going to very much depend on your business, what technology you've got available, and more to the point, what technology your staff have got. Bearing in mind that this day and age, as it is right now, there isn't going to be a perfect solution. That's going to be hard to find. I think we all have to accept that. But at the same time, it doesn't remove our legal obligation to do everything as best as we can do. The rules are all still there. They still apply in exactly the same way. And bearing that in mind, the dangerous thing to do is to simply put the most convenient and potentially risk excluding some members of staff. You might have some that struggle with IT. They may not even have a home computer, for example. So therefore, if you said, right, we're going to do all of our consultation meetings via video link, yes, it might work for most of your staff, but for some it doesn't. It's a way of trying to find a solution to make sure that everyone's included. It may be that you end up with a selection of different things. So you have video link, you might have telephone calls, you might be able to patch in telephone calls to video link with things like Zoom. For example, you don't have to have the video link option. People can dial in from a landline or a mobile phone and participate in the discussion that way. So it's a question of just making staff aware of that. The best way to do it. Worst comes to worst, of course, even putting technology aside, it is possible It's going to be a lot more time consuming and cumbersome, of course, but it is possible to deal with it in writing if you had to. So you could have a situation where your employee reps are gathering up their responses, questions from their constituents. They email those into you. You look at those, you send your responses back in writing. It's possible. I think that takes a lot more planning. And I suspect if you're doing it that way, you may have to be flexible over your 30-day consultation period. It may end up taking longer than that. But again, it's a question of doing what you can and what suits you best to make sure you comply with your obligations as best you can. So your communications, I think, in the grand scheme of things, relatively straightforward. Also bearing in mind, if you've got remote staff or furloughed staff, inevitably most of you will already have lines of communication open with those people to keep them up to date with what's going on in the business, how long they might stay on furlough, those sorts of things. I think the bigger legal problem is the very last one on your slide there is, what about the employee reps? How will they gather feedback from all of the employees? The problem crops up, it won't apply to all of you, but the problem that's cropped up for some clients I've spoken to recently who've started on this type of process is a situation where they've got employees on furlough. The government rules are absolutely clear that someone on furlough cannot do work for you. So they have been nervous about those employees having access to business email. And that's a very sensible approach to take, to be honest, because the risk is that if they've got access to work email, the temptation is that the intention may be to have it there to keep employees up to date on business activities, in other words, communications from HR or from management. But actually, once the employee is logged onto the system, they're looking at those emails. The temptation is to start opening up other emails. And the moment they start looking at other business related emails, possibly even responding to certain customers or clients, then you're very much into the realms of them doing work, and it could jeopardize the whole furlough scheme and your ability to reclaim the government grants or possibly have to repay sums in due course. So many have taken the approach that they must close down business email. So if that's the case, then HR may well have a list of personal email addresses so they can keep furloughed employees up to date. But of course, there becomes a much larger challenge in terms of collective consultation, because what you can't simply do is hand out a list of personal email addresses to all of the employee reps, giving personal details of all your employees' personal email addresses for data protection reasons, for one thing, and also simply because of security as well. If you're handing around or sending out sensitive company information, personal email addresses aren't secure. So again, it's not a great idea from that perspective. So if you're in that category, it's a question of trying to find a solution to that, bearing in mind also that under Section 188, not only do you have to comply with your obligations and put the arrangements in place to elect employee reps, you also have to give reps suitable facilities and access to employees to allow them to carry out their role. So you can't simply pass it to the employee reps and leave it to them. It's your responsibility to help them to do their job. So one possible solution here is, if you have closed down business email, something you may have to give fairly serious consideration to is to whether you need to reopen it again to furloughed employees, to avoid both of those legal issues that I've just highlighted. But if you do that, then word of warning, you would certainly have to send out clear guidance to your employees about acceptable use of business email during this period, underlining the point that they must not do any work. The only reason that they're allowed access to business email is for the purposes of communicating with each other and employee reps in respect to the consultation process, and that alone. So you have to be absolutely explicitly clear that that's the case. Otherwise, it's going to be a question of trying to find some other solution. Say, you might get employees to give their consent to use personal email, but again, be careful about security. It's not the perfect solution, but nevertheless, it might be, if you've got no other alternative, something you might need to explore. That's all I'm going to say for now on the practicalities. All sorts of people will have a number of questions, no doubt. And with that in mind, I'm going to pass back to Abby to pick up some of those questions. Sorry, to give a recap first. Sorry, Abby, jumping in.
That's okay. I'll very, very brief recap because I want to dive into the questions in our last 10 minutes. So I think some of the key things that we pulled out from today, I've put up on the slide there. Be alive to when that proposal might have triggered your obligations. So you'll be working with people in the business on your plans, and Greg went through carefully the point at which you might have tripped into a proposal for the purposes of making triggering your collective consultation. You will be consulting on your business case, so make sure that you've done your background on that and you can explain that to staff. Will's given lots of information about planning for communication and electing those reps, so some really useful practical tips there. And don't forget the importance of the individual consultation in the overall fairness of the dismissal. So we'll have a look at some questions now. Taking that individual consultation point first, there's been a couple of questions about whether you can run individual and collective consultation at the same time. The answer to that is you can. There's nothing to stop you. A lot of employers like to conclude the collective consultation process first, not least because there could be things that come out of the collective consultation process that impact what you will be consulting on an individual basis. So to avoid having to add in additional individual consultations, often the view is it's easier to conclude the collective process, and then you know all of the issues and all of the agreements on that side of things, to then move into your individual. But of course the ACAS code makes it clear that there are circumstances where it would be appropriate to run them concurrently, provided that on an individual basis, from a fairness perspective, they have had they understand what the collective position is. And one for Will here, what if no employees put themselves forward for an employee rep, or you don't feel that you've got enough to adequately represent the affected staff?
Okay, I mean, it's sort of two slightly different questions there. I mean, on the first one, if you haven't got anyone prepared to put their hand up, general comment on that one first is that, so generally speaking, it's something that a lot of employers fear at the outset, as we don't think anyone's going to be interested. In most cases, they find the opposite's true, and they have plenty of candidates. That said, I think right now there's possibly more of an answer or risk of it happening simply because you may have staff that feel disgruntled, maybe because of pay cuts that you've been put in place. They don't like the fact that they've been put on furlough. You may get staff who are juggling home working and having to homeschool their kids and just simply haven't got the time of day to do it. So I think it's a genuine risk that it could happen that you don't get anyone to volunteer. What the law says on this point is under section 188, it says that if you have put the arrangements in place, so you've given the employees the opportunity and ability to elect reps, but they fail to do so, then you are released from your obligations to consult on a collective basis. What you do in that case is that you have to provide the initial information about the proposal to make redundancies to all of your employees. So you send out a blanket communication to everyone. Beyond that, your collective consultation obligations come to an end. So that's the good news. One thing I would add to that, though, is that you need to be careful about timescales. You need to be confident that you have done everything you can to put those arrangements in place. So if you ask for candidates to put their hands up, and then within a very short space of time, you say, right, no one's volunteered immediately, therefore obligation finished, that's dangerous. I would certainly be inclined to go back first up to speak to employees, again, trying to understand any concerns. And in a lot of cases, if you've got a lot of staff, it's an awful lot easier to communicate with a few employee reps rather than all of the staff. So I'd be doing what you can to encourage people to come forward, but you can't force them. So as long as you've done that bit, you're basically released from your obligation. Second question about, so what if you haven't got enough? Well, again, it comes back to a very similar point. If you've got some employee reps, you're not released from your obligation, because that only kicks in if they fail to elect anyone. But it's really a question of, I think, in that circumstance, of doing the best you can with the employee reps that you have got. Coming back to Greg's point, you just need to make sure that your staff have got a voice. So it'll be a question of having to put the arrangements in place to make sure that the few employee reps that you have got then communicate with the whole staff body, rather than possibly the smaller group that you had in mind to start off with.
Great, thanks, Will. Greg, one for you. You've spoken about the establishment. What do you think, if any, there are any changes with people now working from home who are told, not for social distancing reasons, not to come into the office? Does that change how we view establishment, the purposes of numbers?
Well, for the purposes of the establishment, the definition, I think if people are furloughed or working from home, and presumably, let's assume that it's a temporary measure. I think if it's a temporary measure, you would just analyse the establishment based on what the working situation was pre-furlough or pre-working from home, and then identify the establishment from there. If they are permanently working from home, they're remote workers. I've touched upon that in terms of some of the case law, and you need to look quite carefully at the way the establishment is set up, how it's managed, its customer base, movement between different sites, that sort of thing. But it's very fact specific where you've got mobile workers.
Thanks, Greg. Another question, Will, for you, I think. If we can't get a trade union representative or another representative to attend a meeting, how many times would we have to postpone that, or do we have to postpone it? What's your thoughts on that?
Okay, I mean, on that one, as far as collective consultation goes, there's nothing spelt out in the law about an obligation to postpone a meeting. You do get that for things like disciplinary hearings, where there is an obligation to postpone if a rep isn't available to accompany someone. That doesn't apply here. So strictly speaking, there isn't a legal obligation to postpone at all. But I think we all have to be sensible about current circumstances, that you may well get reps with all sorts of other conflicting commitments at the moment that make it difficult to attend possibly at a specified date and time. And your overall obligation is to conduct a meaningful consultation. So I think some degree of flexibility is a good idea. At the same time, you don't want to hand over complete control and flexibility to your reps to dictate the whole process and drag it out. So it's perfectly acceptable to have a set timetable, and you certainly want to stick to that as closely as possible. I think it really comes down to a sensible, good advanced planning. Because if you have your meetings in the diary in plenty of time in advance, if any of your reps have got problems with that because of other commitments, they can tell you in plenty of time in advance, and it should be a question of having to shift possibly by an hour or so rather than have to move it by days and days. So with decent planning, you can set your own timetable. So you need to be sensible about flexibility, but not go overboard, because otherwise it's already going to be a cumbersome process, more cumbersome than otherwise with the extra challenges we've got. So you can stick to your timetable pretty closely.
Thanks, Will. We've only got about a minute left. I can see there's a lot of questions on, can we serve notice when they're on furlough? What rate is that going to be paid? Just very quickly, there's nothing in the guidance on furlough that says you can't issue notice during period of furlough. The rate of pay is a bit more complex. It's largely, well, it will depend on things such as what's in the furlough agreement with the individual, what they've consented to, what their minimum notice periods is. So it is a more complex area with no definitive guidance on whether it's the 80% or their full contractual rate. It will depend based on the individual arrangement. What we will do after this is put together, as we did last week, a Q&A or an FAQ sheet with some of with the questions that have come in and our answers on that, which we will circulate with a copy of this video and the slides on our website. So do look out for that. And thank you very much for attending. Do tune in next week for managing disciplinary and grievances remotely, which I think will be another really useful one with practical tips. But have a lovely day, and we look forward to seeing you next week.